Wait, please, Your Lordship. I beg to mention item number 36. Lordship, I believe the case diary has not been received in this case.
Case diary not received, my lord. Petitioner is in interim.
CD not received, placed again on interim to continue.
Deeply obliged.
19.
Between item 42, Lordship. Hearing, Lordship. The concern of the taking concern of the other side, Lordship. Not the other side. But they were taken up to 2 weeks, Lordship.
On the prayer of learned counsel for the petitioner and with the consent of the respondent side, place the matter again on.
Lordship.
32, no?
I please, Lordship. Lordship, I beg to mention item number 43, 44, and 45. I am for the respondent, Lordship. Consent has been taken from the other side, Lordship. Matter may be fixed after.
Lordship. Prayer of respondent. Okay. With the consent of the petitioner. Is the matter again on? When do you want?
2 weeks, Lordship.
Lordship, in item 43, there is an interim order.
3, you're right.
43.
Interim order passed earlier to continue. Next date of listing.
All right.
Please, Your Lordship. I beg to mention item number 17, Lordship. Kindly adjourn for the day as my senior is not available for.
Petitioner.
Yes, Your Lordship. No, Lordship. I'm for respondent, Lordship.
State has filed this revision petition.
On the prayer of learned counsel for the respondent, list the
Another 11. Another pair for item number 30, Lordship. CD is not received.
1-3.
30.
0,
CD not received.
Sit submitted, my lord, in this case.
Is submitted that our sheet has already been submitted. So what do you want to do?
Adjourn for the day as my senior.
The prayer of learned counsel for the petition, list
28-1. 28-1.
Oblige, Your Lordship. Please, Your Lordship. Lordship, I beg to mention item number 32, as my senior could not come to the court due to medical emergency.
Not received, my
CD not received.
Kindly, matter may be fixed on 30 January, Lordship.
All right, place the matter again on 30th of January.
May I please, Lordship? Lordship, I beg to mention item number 22 for adjournment.
Yes. When do you want?
Any date, right, please?
Counsel for the petitioner, place the matter again on.
LCB matter, I mean.
কাগজ আছে মোৰ টেবুলত মোৰ
This case, Your Lordship, kindly call for the case diary regarding the recovery of fake currency note. Today is 51 days.
call for CD.
Not looking for.
3rd of February. 3rd February, 3-2.
Oblige.
Wait, please, my lord. Wait, please, my lordship.
Yes.
My lord, in this case, one
connected BA number 72 of 2026 filed by another co-accused person is already fixed tomorrow, my lord, for hearing, for CDN hearing. May I play it at the same? This may be also fixed along with the same.
It is submitted that
72.
another bail application arising out of the same FIR is fixed for case diary on 21. Hence, list the matter along with the said case, that is
BA number 72 of 2026.
21.
Deeply obliged, my lord.
Wait, please, your lordship. Lordship, this is a regular bail application, lordship. In this case, lordship, the co-accused already approached before this honorable court and coordinate bench has allowed lordship interim protection to all the person lordship who has approached before this court. Here, three petitioners, they are not named in the FIR. Lordship will find the FIR on page 17. Allegation is that lordship, the police personnel in civil dress, lordship picked up of one person, lordship, Baharul Islam, lordship, and that person raised Halal, lordship. When raised Halal, lordship, there was a cricket match was going on, lordship. The local people gathered there, they come to rescue this person, lordship. And in the meantime, that Baharul escaped from the club, from the police, lordship. So this petitioner, they were directed to produce that Baharul Islam because they are the local villager, lordship. They are not connected with any offense, lordship, because that police personnel came in a vehicle, lordship, private vehicle, without showing their identity, lordship. That's the lordship situation arises, lordship. That's why, lordship, on motion, lordship, the coordinate bench has granted bail, that interim bail, lordship, that all on page 30 onwards, lordship. I'm on the parity, lordship, because this petitioner also, lordship, when they are lordship, and as per lordship direction, lordship, the petition number 2, when they are as per direction of the Bihupuria police officer, OC of the Bihupuria police station, lordship, he was asked to go there and to inform the OC, lordship, what has happened there, lordship. But he was also picked up by the police personnel, lordship.
Your lordship may kindly peruse last portion of the FIR, page 18. They, in fact, my lord, attacked the police personnel, and thereafter, my lord, the group then snatched the apprehended individual from police and vandalized the vehicle of the police, used and my lord, severely injured us. So, my lord, they, my lord, rescued, my lord, snatched one apprehended accused from the custody of the police. And my lord, regarding the in earlier bail petitions regarding granting of bail to other accused person, your lordship may kindly peruse page 35, last portion. So, my
That
lord,
is anticipated bail
and
application.
parity, my lord, and whatever may be, but my lord.
This is the anticipated other regular
Considering
bail
the
that
fact
is on
that the
page 30,
next
lordship.
few days are not working days in this court, therefore the petitioner. So on that pretext, my lord, because at that point of time.
Lordship, can you come to the lordship? Since lordship, they are on parity.
And-
Those persons are named in the FIR, lordship. These present three petitioners are not named in the FIR, lordship.
Cannot be a ground, my lord.
Because lordship is the same FIR, lordship. Because they are not named, lordship. Those who are named in the FIR, they are approached before this court, and court has granted lordship in protection to all of them, lordship. I will also, lordship, may I pray for the parity, lordship? I will cooperate with the investigation. Let the petitioner appear before the, after release, lordship, appear before the investigation officer and record their statement, lordship. And let all the case may be fixed on 29, lordship. In the meantime, I may be protected, lordship. They release this petitioner on interim bail, lordship. If any adverse come, lordship, may reside to the bail of this petitioner, lordship.
When were you arrested?
Same day, lordship. Same forwarding on that is forwarding, lordship, will find on
30,
page
25, my lord.
forwarding, that is on page 20, lordship. 13/12/2012.
30/30/12.
30/12/2025, lordship. As per FIR, they said specifically 10% name as their lordship and 15 to 20 more percent lordship without specifying their name. This petitioner are not preventing the arrest of that person lordship. The police personnel came in a lordship, civilly dressed lordship, in a private vehicle lordship. Even they have not shown their identity card to at least to assess that local gathering lordship that they are the police personnel, not the other person lordship.
We have dealt with this case before also.
Yes, lordship, last occasion it's fixed before lordship. On that day, lordship, I've made a prayer lordship. Other case is fixed before the court number 24 lordship. Their Honorable Justice lordship, Pranjal Das lordship. Then lordship was transferred on request lordship. It was transferred to that court lordship. That time that court was sitting lordship. Now this court is not available lordship. That court is not available. Lordship.
So it is fixed for CD on 28 anyway.
28, but they are on interim bail lordship. They are all on motion lordship, allowed the interim bail lordship.
AB, my lord, already here.
No,
Not
AB
on
and
motion.
AB. This is a regular bail lordship.
They were not granted interim on motion.
Because lordship, others are on motion lordship, there is granted lordship. This coordinate bench has granted lordship. Can you peruse on page 30 lordship? Regular bail, they are named in the FIR lordship. I have annexed all the person lordship. There are for. I have mentioned the cases lordship. All the cases lordship, they are granted interim bail lordship. Those who are for a anticipated bail, those are for regular bail, they are granted interim on the motion bail lordship.
Case 31 says CD not received. Then how can it be on motion?
Yes, lordship, because that was on that day lordship, other cases was there lordship. All the cases are tagged together lordship. That's why lordship. And BA number 5/2025 lordship, their CD was called for lordship. And all these cases are tagged with that BA 5/2025 lordship. That petitioner name was Bilal Hussain lordship and others. That's why lordship, since CD was not there on the motion, it was granted lordship.
Learned counsel for the petitioner. Go to page 30. Okay. Same order. Para 1, 2, 3. The 5, in paragraph 5, you write FIR named accused persons have been granted interim bail by order dated 09/01/2026. Bail application 57 of 26. Furthermore, some of the co-accused were granted pre-arrest bail. By order 09/01/2020. Bail application 69 of 2026. Having regard to the above and the fact that the present petitioners are not FIR named accused persons, it is provided that shall be released on interim bail of rupees 25,000 each with one surety of like amount each. That is Tilaka Magistrate. Stick to the condition. Same conditions. List again on 28.
Highly obliged.
And along with that first case number I have given that. Page 30 case number.
Paragraph 6 in page 7, Lordship, I
57,
mentioned the other
20.
case number. Highly obliged.
Item number 4, my lord, earlier one instruction was called for regarding, my lord, registration of any case against the petitioner or not, my lord. Your lordship, I am trying to get probably after some time I will get the instruction.
Also ignorant about the status of the case, whether it is registered or not. But I have given my statement. I have recorded my statement before the person.
Can we let him get his
Yes,
instruction?
yes, Lord. I am on protection
After some time we are having
for some time. Okay.
Tomorrow? my lord?
tomorrow.
Tomorrow.
All right. The prayer of learned additional PP seeking time to obtain instructions. Raise the matter again. 21. Interim order passed earlier to continue.
So tomorrow at 2, if possible, I have another bill.
We don't know about that.
Good. Put to a problem, my lord. 5 also, my lord, same one report was called for report, no.
Not received. Report as called for has not been received despite issuance of reminder. Who is directed to furnish the report positively by the next date fixed. Till then no coercive action will be taken against the petitioner. List the matter again on
28.
May please, Lordships. This is, my lord, a pre-arrest bail application, my lord. In this case, my lord, kindly have a look at page 13, my lord. The FIR lodged by the, my lord, other side, my lord. And there is, my lord, a cross FIR, my lord, on the same day, my lord. On the same day of incident, my lord, both the parties have lost their FIR, my lord. But their FIR has been registered, but our FIR has not been registered. But I have annexed our FIR also, my lord. At first, my lord, in their FIR, my lord, kindly have a look at page 13, my lord. Yes, sir. May I read, my lord?
yes.
Respectful humble submission is that today on 21/12/2025 at about 3 p.m., I along with my elder son Mijanur Akant and Saddam Akant were cutting big trees lying on my Madi land. In the meantime, the aforesaid accused persons have prevented in cutting the trees and forcefully claiming that the said land belongs to them and threatened to kill us. Thus, the aforesaid accused persons have surrounded us and started to assault us, and accused number 2, Habibur Rahman suddenly trying to assault on the head of my son Saddam Akant with a dagger, and my son sustained serious cut injury on his forehead. When there was excessive bleeding on the forehead of my son due to assault with dagger, the accused persons fled away from there. It is noted that the accused number 2 killed his father by assaulting him, and accordingly he also threatened to kill us and left from there. My lord, there was actual fact is that, my lord, there was some minor dispute regarding a plot of land, my lord. And on that plot, my lord, there was some village mail also, my lord, but that dispute could not be settled, my lord. And on the day of occurrence, my lord, on 21/12/2025, my lord, at 3 p.m. my lord, around 3 p.m. My lord, when the my lord informant side engaged my lord some persons for cutting those trees lying on the my lord disputed land my lord, and then the my lord the petitioner number 2 my lord Habibur Rahman my lord prevented them my lord, and on when the my lord the informant side my lord so the Habibur Rahman is coming my lord, then some 2 persons from my lord, those who were cutting trees my lord, fell down from the tree my lord, as because they were cutting the my lord branches of the tree my lord. And accordingly my lord, our FIR, kindly have a look at page 18 my lord, our FIR, page 18 my lord. Respectful humble submission is that at about 1 year back, the below name accused number 2 had induced one of my family member and also took some land documents from her, and in a conspired manner got mutation over a plot of land measuring 1 bigha 11 lesas in his name and illegally occupied the same. I have raised allegations on the matter before the villagers and village headmen and elderly persons of the village, but the accused did not pay any heed, and hence the said matter has not been settled. On my said land, there are some big gamari trees. But regretful matter is that on today, that is on my lord 21/12/2025, my lord, at about 9 a.m. at morning hours, the accused number 2 engaged two tree cutters, my lord, tree cutters, and after cutting 5 numbers of gamari trees, they made wooden frames and were taking away the same. And at that moment, my lord, at that moment, I noticed the same and prevented the accused and also asked the accused person that he will be allowed to take away those wooden frames after settlement of the land dispute, which is yet to be settled. But immediately after saying this, the accused number 1 attacked me and with khurki, as a result of which I have sustained cut injury on my hand. Later on, the accused number 2 kicked me and fell down on the ground. Accused number 3 also attacked me with sharp khurki and I have also grabbed him. At that moment, the accused number 1, 2 and 3 have surrounded me from all corners and indiscriminately assaulted me by using kicks and slaps and assaulted me by wooden frames. As a result of said assault, I have sustained serious injuries on my eyes and other parts on my person. Later on, while I was somehow able to save my life and running away from there, the accused number 4 and accused number 5 have surrounded me and accused number 5 caught hold me and accused number 4 has started to use slaps. I was again able to save my life from the clutches of the accused persons and fled away. It is noted that accused number 6 has arranged and
Your FIR is not registered, is it?
yes, my lord.
Hmm?
Our affair on the same day we have lost, my lord.
Was it registered?
Not my lord registered. Yes, because their affair has been registered, my lord. But both the affairs, my lord, lost on the same day, my lord. My lord, some dispute, their relatives, my lord, some dispute.
Lost on the same day, but returned after some time.
Yeah, my lord, as because we have also sustained injuries. And my lord, they have also sustained injuries, my lord, by falling from the tree, my lord, while they were cutting trees.
And what action did you take for non-registration of your FIR?
My lord, they have I have instructed them to file a complaint before the SP, my lord, of the concerned district, my lord, Kokrajhar. My lord, at this stage, my lord, we may be allowed to, my lord, cooperate with the investigating agency, my lord. Then there will be all the matters will be, my lord, clear. Otherwise, some dispute is there, my lord. Land dispute is there. So that we may be able to, my lord, cooperate, my lord, on any condition, my lord.
Yes, prosecution.
My lord, only CDN injury report will reveal the actual fact because the accused number 2, my lord, there is allegation that he is also earlier involved in assaulting his father and killing his own father. Accused number 2. So, my lord, there is because allegation is already there regarding that assault. So it cannot be said that they are not at all involved in this case, my lord. And more important is that, as your lordship has rightly pointed out, their FIR was not at all registered, my lord, and they have not also lodged any complaint, my lord, regarding that aspect till now. So only injury report is the, my lord, will reveal the true facts and the CD. my lord.
My lord, if injury report may be called for, my lord. Otherwise, if some adverse will found, my lord, my bail petition may be rejected, my lord. Otherwise, there is nothing, my lord. Injury report, we are confident that injury report, my lord, will reveal nothing, my lord. Some minor injury is there, my lord. Altercation, my lord. Both parties, some minor altercation there, my lord.
Learned
We'll
counsel for
cooperate,
the
my lord.
petition, learned ladies. An application under. Students, so. Paragraph 2 is stated that the aforesaid FIR has been lodged as a counterblast to the FIR lodged by the petitioner number 2 respect of an attack upon the petitioners by the informant side of the present case. And it is further submitted that the incident took place as a result of dispute regarding ownership of the land where the trees were situated. Call for the CD. Agreement is provided that in the event of their arrest, the petitioner shall be released on bail of rupees 50,810 each to the satisfaction vesting authority. Interim pre-arrest. Further provided that the petitioner shall appear before the IO within a period of 7 days from today. They shall cooperate with the investor. Is the matter again on so and so. CD along with injury report, okay?
Obliged, my lord. Much obliged.
13-2.
13 to me.
Fake doctor, my lord. Fake doctor, my lord.
Fake doctor.
Yes.
None appears. Let us have it after some time then.
Without my senior on leg, at the time.
Your Lordship, this period bail application, my lord. Now, my lord, matter relates to mutation by right of inheritance. And my lord, there is no dispute and no patta holder raised any objection. But here FIR lodged by Gao Pradhan, my lord, saying that he did not issue the legal heir certificate. This is the case, my lord. Is my lord 8. Otherwise, my lord, regarding mutation, no objection raised from any corner. Page 8, my lord, is stating that he did not issue any legal heir certificate. Eventually, he issued one income certificate. Later on, it has been made out as legal heir certificate. This is the allegation. Now, my lord, page 28, my lord, kindly have a look, my lord. My father name appear under serial number 45. My father name Kurpan Ali, and I am, my lord, one of the son of the Kurpan Ali, and I am a journalist, my lord. I enclose the document. And in place of Kurpan Ali, when he demised, the legal heir, including the petitioner, has been mutated. That is page 30, my lord. kindly have a look, page 30. The Assamese vernacular. May I read, Lordship?
After perusal of the CD, your prayer was rejected by the
No,
session, so we'll
all-
have to
all
call
other
for the
links
CD.
are already been allowed.
But-
Page, my lord, 30.
No, all may be allowed, but there is a reason for your
That
rejection.
is kindly have a look, page 30. Because this is a proper mutation order. Why is the learned session code rejected only one person and allowing other person? Here, my lord, right of inheritance, this mutation order was passed, that is page 30. Chakra Bikhoyar, Ponoro.
There is allegation of forgery.
Lordship.
Mutation
but-
orders are
but-
illegally passed all the time.
But all other, my lord, 2 brother and 2 sister are already been allowed. Only
Allegation of forgery is against you,
only my prayer rejected, my lord. So, my
Yes.
lord, I will cooperate because.
probably rightly. Call for the CD.
Please. So, interim protection will be given, my lord. Page 32.
Yes, next item.
Date will be given, lordship. Short date will be given. Date. Obligation.
Out of same affair, another bail revision is pending, my lord. Out of same affair, another bail revision pending, which is fixed on 22, my lord. Is BA number 37 of 2025.
Is the matter along with BA
37 of 2026,
on
22.
22. Second.
Obligation.
May I please, your lordship? Complete false FIR, lordship, 482 application. Lordship, allegation is that I have committed rape. A person aged about 70 years, is it possible, my lord, for committing rape? Even he cannot properly walk. Page number 13, lordship, FIR. The real fact of the matter is that the husband of the informant taken loan of rupees 20,000. When he demand back, the accused person demanded his money back, then this conspiracy made and this FIR has been lodged. So, lordship, may I pray for interim protection, lordship? Because about 70 years old man, lordship. As per documents, 68 years now he is. Protection may be given, lordship. If anything found, it may be rejected, lordship. Call for the CD with fair protection, lordship. Because no one can believe this.
Yes. prosecute.
Otherwise, from the FIR, my lord, it reflects that Assamese ঘটনাস্থলীৰ পৰা দৌৰি পলায়ন কৰে. So whether he can walk or cannot, and whether he has committed the offense, only CD will reveal. And regarding the age factor, my lord, he in his petition, he stated that he is about, my lord, 68 years. So his submission is that, my lord, whether yes, there are many instances, my lord, who is even 80 years of person has committed this type of offense. Cannot be a ground, my lord. At this stage, my prayer, only victim statement will reveal the true fact, my lord.
Yes, yes, I am also saying that CD may be called for, but lordship, protection may be given because of his age. If anything found, it may be directly rejected, my lord. Because a 68 years person, lordship, even he cannot work properly, and the allegation is that I have, at the very beginning, I am saying that completely false FIR. Only because of 20,000 rupees he has taken, the husband of the informant. When the accused person demanded his money back, this conspiracy made an FIR lodged.
Where have you stated that he cannot walk?
Maybe inadvertently it is left, lordship. He will fully cooperate with the investigation, lordship.
I'll learn counsel for the petitioner. Learned additional PP. The allegation, this is an application under so and so. The allegation against the present accused person is that he entered into the house of the victim and committed rape her upon making hue and cry when her daughter came, the accused fled. The it is submitted on behalf of the petitioner that that there exists a monetary dispute. No, don't write monetary dispute. That the victim, husband of the informant, took a loan from the accused person amounting to rupees 20,000, returnable within a month, but he failed to return the same. Upon being pressurized by the petitioner, the government lodged a completely false FIR against the petitioner. Also, it is further stated that the petitioner is a 68-year-old person who is not even able to walk properly. And considering his age, interim protection may be granted. Para called for the CD along with medical report. In the interim, it is provided that 1,001 surety. It is further provided that the petitioner shall appear before the IO within a period of 7 days and cooperate with the investigation. List again.
Obliged, highly obliged, man.
May I please your lordship? My lord, here the petitioners are own brother lordship. Here are 3 petitioners lordship. Lordship, this is an anticipatory bail application lordship. The FIR is at page lordship. The translated copy is at page 10 lordship. Lordship, the FIR was lodged on 8/12 lordship. And the alleged date of incident on 30/11 lordship. And the fact of the case is that lordship, on that very day lordship, some altercation took place regarding lordship, one lordship battle nut loaded trucks lordship, and the matter was already compromised at the village level lordship. Your lordship may kindly peruse the FIR lordship, page 10 lordship. So page 15 is the compromise meeting of minutes of the compromise meeting lordship. There is a village level compromise was also held lordship. So at this stage lordship, your lordship may call for the case diary lordship, and may be protected, Lordship. Because this is a Lordship village altercation, Lordship, regarding one loaded, metal nut loaded truck, Lordship. The altercation took place between the petitioners and the Lordship, alleged victim, Lordship.
Where is the order of rejection? By session judge.
My lord, that was not annexed, Lordship.
Very good.
That was not annexed here.
All right, call for the CD.
My lord, CD along with the medical report, Lordship.
Yes, along with medical report.
I will not provide to. Right.
During this statement, service on R3, respondent number 3. My lord, we were directed to take steps. We have completed filling of steps. Steps have been taken. My lord,
You are appearing for
And for it 2, 4 and 5.
2, 4 and 5. So nobody is appearing for 3.
vision against
Councils have entered appearance for 3 as per office note. Name is shown.
3. We will discuss.
P. Mohanto. P. Sharma. Then all the shown.
Service is complete, my lord.
As per office note. Service on respondent number 3 is complete and councils have also entered appearance whose names have been shown in the cause list. Service on remaining respondents are already complete and appearance has been entered by learned counsel. Hence, lays the matter when?
2 weeks, after 2 weeks, my
For admission.
right, my
Please go.
Lord, this is a quashing petition which ought to have been filed jointly by petitioners and the respondent number 2. However, my lord, on account of non-compliance of R2, we are constrained to approach your lordships. This quashing petition is predicated upon a settlement agreement, my lord, which your lordships would find at page 124. My lord,
My lord, before he starts, I would like to point out one thing, my lord. Now, although, my lord, there is some compromise petition earlier between the parties and matter. Now, my lord, my lord, respondent has also filed objection, my lord, because of some reasons I am not aware about those things, my lord. Now, if, my lord, now the respondent has already filed objection regarding on the basis of the earlier compromise matter or whatever matter, on what grounds objection file, I have not gone through. But my lord, here, if my lord, now respondent has objected to the matter, my lord, in that case, my lord, LCR would be, my lord, necessary.
may I please make a submission to that aspect, my lord? My lord, the objection,
LCR not yet received.
sorry, if I may.
LCR not yet received, my lord.
My lord, with respect
Not
to,
even called for.
my lord,
Yes.
with respect to that objection petition filed by R2, my lord, he has raised 2 objections, my lord. He says that I came to know in March that the settlement amount of 11.25 crores, which has admittedly been paid to R2, he has enjoyed the fruits thereof. Thereafter, he has given consent for bail before the Honorable Supreme Court, order attached, bail before this Honorable Court, which culminated into a final bail. He says, I was under a belief that with respect to the companies, the liabilities were to the tune of 3 crores. And he says, I very bona fidely believed the representations of the accused persons to be true and correct, advanced way back in 2021. When in 2023, you are getting an FIR registered against me, virtually impleading all the IPC sections. Point number 1, my lord. He had enjoyed benefits of 11.25 crores. Point number 2, my lord. This is nothing but contempt, my lord, where he was privy. He has stated so on oath in his affidavit that in March, I came to note that the liabilities are exceeding the amount that I'm receiving under the MOU. Still, my lord, he is making a submission before the Honorable Supreme Court, giving consent. He never objected. Before your lordship, when petitioner number 1's bail came to be, bail petition came to be listed, interim bail was granted on basis of his submission. He never objected. That culminated into a final order. He never objected. My lord, when this petition came to be filed in September 24, he had duly entered appearance on 28/2025. My lord, he kept mum for the entire period, and only this objection came to be filed in January when some GST orders came to be passed against him. As per the settlement agreement, your lordship, with utmost respect and humility, everything was put to rest. It also records that we are executing this agreement understanding the full legal ramifications. It was also admitted that after today, all the liabilities, statutory or otherwise, of the two companies
So
shall
what
be.
are we supposed to do today?
My lord, my humble submission is that your lordships ought to grant indulgence to us, my lord, and quash this petition. I have 2 judgments to support that. My lord, there was a case where a party entered into an agreement, enjoyed the fruits,
What
and
is the stage of the proceeding now?
Sorry, my lord, regarding that only stage of probably search sheet filed or not, but they
Not
have
filed.
challenged the FIR for quashing of the FIR, so I will have to get the CD, my lord, not LCR, PCR, my lord.
your lordships have actually captured the factum of execution of the settlement agreement during these proceedings, vide order dated 28/2025, when the respondent number 2 entered for the first time. Your lordships, the learned predecessor bench had duly captured that essence. However, in the generosity, R2 was directed to file a reply. Lord, there's a judgment of the Honorable Apex Court which says that once a compromise has been entered, parties have acted, enjoyed the fruits. At a later point in time, if one party tends to resile, it's nothing but abuse of process of court. And 482 empowers this Honorable Court to quash such proceedings.
There is already an order calling for the CD.
My lord, what has happened on the last date, there was some confusion, my lord. The matter was directed to be listed for some other day. As per the case status, the order came to be passed something different. So when we inquired, ultimately the matter was jointly requested to be listed for today. Subject to your lordship's wisdom, my lord, if my lord wants the CD to be here, my lord may please direct so. However, my lord, in my respectful submission, today we don't even need the CD, my lord. Much water has flown, my lord.
Yes, respondent number 2.
Judicial order is there calling for the CD. He has not filed any modification. If it is not correct, he should have filed one modification.
Sir, I very
One
candidly
order
said,
is there.
subject to your lordship's
Not
kind
at the-
direction,
at the-
I am submitting
at
to the
this stage
jurisdiction
now,
of this
it is the
honorable court,
duty of
sir.
the- I mean.
I can never try to raise any affront to the sanctity of this court. I am submitting myself to the jurisdiction of this honorable court, sir. I am just requesting, if my lord deems fit, my lord may pass necessary orders. My lord, allow me to take you through, take your lordships through the counter affidavit, my lord, that has been filed.
We
Complete-
either hear the matter or we don't hear the matter. We don't want to do both.
Right, my lord. Whatever my lord deems fit, my lord, we are ready for advancing our arguments today. It's a very short issue.
But otherwise, the learned friend on the other side is insisting on the judicial order calling for the CD.
Whatever your lordship deem fit, I am in your lordship's hand.
Why do we need the CD?
aspects are there. But one is financial, one is criminal. So far as financial aspects are concerned, one agreement was there, but subsequently it came out that even that agreement was fraudulently entered into by the, was forced to enter
Right.
into.
It appears that earlier CD was called for, but the same has not been received. Highway is directed to submit the CD on the next date fixed. List again on, yes, given it.
Or password.
My lord, may I request for 12th, if that suits your lordship's board? 12th, sir.
24th would be property.
Hmm?
24 to.
Please, my lord, I'll be obliged. My lord, may I make a small prayer in the interim, my lord? We are, now that much water has flown for 2 years, we are apprehending that something or the other might not be precipitated by R2 given the affidavit in objection, raising all sorts of allegations. My lord, may at least protect me. 11.25 crores I have defrayed, my lord. Supreme Court has taken cognizance of the settlement agreement. Bail was granted basis that. My lord, may kindly grant me that indulgence.
But in the affair, what we have alleged, noted, amount of 139 crore was siphoned off by the petitioner from the company lordship. Talking about 11 crore.
But you could,
139
my lord,
crore.
still he went ahead and signed this agreement and gave a no objection before the Honorable Supreme Court.
Lordship, it
Is
was
this the submission
at-
today of
at the
respondent
point
number
of
2, my lord?
entering into the agreement, Lordship, that GST amount was shown as around 3 crore.
Nothing was shown, my
Now
lord.
it
Please
came
have the
out to
agreement.
be
I can
18
show
crore.
that from, my lord, he says that I was under a belief of 3 crore of GST. Why did he execute an agreement for 11.25? Was this a recovery proceeding for him? My lord, may kindly grant me indulgence to that effect, my lord, that no precipitative or coercive action may be taken against me, because I am highly doubting the intentions of R2 today, my lord.
This stage, my lord, only after already matter is pending since already CD was already called for on. For perusing the case, there if any further order is.
Sir, what is the harm that will be caused? 2 years I've been made to run for my liberty after defraying 11.25 crores as against a submission of 3 crore. Now he's raising 18 crores out of thin air, my lord. Saying that I am so innocent that I am relying on accused representation to sign it.
In the interim, no coercive action will be taken against the petitioner.
I'm so deeply grateful, my lord. I'm so deeply grateful, my lord.
My lord, I challenged, my lord, one proceeding, criminal revision petition pending before the learned court of Church Silchar, my lord. This case, what happened, my lord? This petitioner before your lordship filed one petition before the learned executive magistrate apprehending breach of peace and tranquility in the locality. Thereafter, my lord, police report was called for, and it is, I have annexed, my lord, at page, my lord, 18. And learned magistrate being satisfied upon this police report, he passed one order while issued notice to the opposite party, and attachment order was also passed under section 165(1) BNS, my lord. Earlier it was 146(1), my lord. Page 19 is the order. Then, my lord, against this interim order, opposite party filed one criminal revision petition before the learned session judge Kachar Silchar. This is page 20. Accordingly, learned session judge, having taken cognizance of the matter, passed the interim order at page 25. And against this order and this impugn proceeding itself, my lord, this petitioner before your lordship. On the ground that.
But
my
it
lord-
is only an interim order.
Yes, my lord. My lord, in this regard, my lord, ground of challenging this proceeding and interim order is that, my lord, as per my lord section 397, my lord, earlier, now it is, my lord, 438. Here, my lord, it is specifically provided under clause 2, my lord, when interim order is passed, my lord, criminal revision petition is not maintainable. Now, my lord, 438 BNSS subsection 2, my lord, the power of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial, or other proceeding. Original magistrate, my lord, having taken cognizance of the matter,
So that is the only issue.
this is the only issue, my lord.
Yes.
My lord, my learned friend has brought a wrong case in the wrong premises, my lord. Your lordship can see, the land belongs to my sister. In fact, I have filed an application also before, this is before the lordships. They have filed a case against Binoy Kumar Singh, but the land does not belong to, land and the house, concerned house belong to his sister. And his sister is not made a party here, my lord. Now, I'm a school teacher and recently retired. Now the proceeding against me. So I have filed this application, your lordship, maybe it is also there, my lord. May I see the application, my lord? And in these premises, I filed the revision before the session judge. And your lordship kindly see, page 20, my learned has said that I have approved the learned session judge against the interim order under section 438. Here, I have approved the session judge under section 438 as well as also under section 440, your lordship, page 20. Page 20 is there. Then can you see the next page? Next page, my lord.
My lord,
The petitioners.
my lord, without going through, my lord, it is a matter of old matter, my lord. There is, thereafter, my lord, there was no information regarding any untoward incident, my lord. So, my lord, matter may be disposed of, my lord. To decide the matter, my lord, by the session judge, my lord, without further delay, my lord. And this ground I have taken before your lordship, petitioner may be given liberty to raise this petition maintainability there also, my lord.
It is absolutely a civil dispute. But they may have a case, my lord, against some other person, not against me. And my lord, your lordship carries into my petition. Wherein I have stated that the land belongs to my sister. She has a rented house, original shop house. She is running the old lady of, she is the old lady of 80 years, widow, with her children. She is living there on. And they have filed a case against me. Whereas I am a retired teacher, recently retired. By the time I was in service, in the years 60th of my life, service age, my lord. Now, the last in the December, so I retired. Now I am
So you have no difficulty if it is decided by the session judge?
Yes, my lord. I have approved the session judge. It is
And I will
a
raise
civil
my
matter.
maintainability issue.
It is absolutely a civil matter. I
Okay.
should approve the civil court.
Learned counsel for the petitioner as well as learned counsel for the respondent. As agreed to by both sides. This criminal petition is disposed of with a direction to the learned. Who additional session judge?
That is passed, my lord, like that.
Additional session judge Kasar to dispose of the proceedings in criminal revision case number 79 of 24. On merits as early as possible. Preferably within a period of 3 months. The date of this order. LCR has been received.
Yes, sir. No scan copy received. That is the.
My lord, only my lord liberty may be given, my lord, to raise my lord maintainability of that revision petition before the concerned court.
It is up to
Merits
the-
means everything.
My lord, this is my lord, their legal
Merits
point.
including the question of maintainability.
Maintainability. Obliged.
If you raise the question of maintainability, can he say I will not hear on the maintainability?
In course of time, my lord, a long time has elapsed, my lord, and
Hmm.
there is nothing happened untoward.
Obliged.
Therefore, my lord, I considered well.
Much obliged, my lord.
Made please, your lordships. In item number 15, I am the respondent number 2, and item number 16, I am the petitioner in this case, your lordships. And the item number 16 is the so item 15 is the outcome of the item number 16, your lordships. And I will place the entire facts before the honorable
Before my
court.
lordship starts, lordship, I have received the copy of the criminal revision petition on lordship 2511. I need to file a written objection, lordship, within this week, lordship. Lordship may kindly take up in the next week.
Your lordship, long back then, your lordship, already in 11 we have served a copy.
Not 11, 2511. 25, thereafter,
lordship,
clarification and
no, lordship.
discussion ensued, lordship. And apart from that, I am a security person, lordship. I remain in this post sometimes.
So there is a lot of facts to be revealed before this honorable court. Then and the entire thing has to be.
Okay, 1 week. Right. On the
Next week on, let me fix your lordship next week on Friday.
Learned Council for the
Wednesday, your
petition.
lordships.
On the prayer of Learned Council for the sole respondent.
Respondent number 2, lordship,
Then number 2,
in item number 16.
who has submitted that he has received the copy of the petition. 20. When did you receive?
2511. lordship.
25/11/25. 1 week's time is granted to file. Opposite.
Let me fix your lordship.
Is the matter again on?
Wednesday. Huh? Date January, no? Oh, deeply obliged.
In any lordship, item number 15.
But that has not been. your lordship.
Continued, lordship, time to time continue.
This was in 16
This one 16, lordship. In 15,
to 16 not Asil. And 15, what about 15?
15, lordship, your lordship has stayed the order of the learned trial court, lordship. Honorable, right? And time to time it was extended, lordship.
But the thing is that if
Please the matter along with petition 73 of 25 on 28/1/25. Hearing order passed earlier to continue till the
Can it be lordship 29 January, lordship?
no lordship 28, no?
9 January.
28, your lordship.
And I have some, that is lordship, not 28.
So if you have any genuine difficulty with then object.
Because lordship, my dialysis schedule is on Tuesday, lordship.
Oh.
And then Wednesday I remain in this post.
All right, 29.
Much better. That is what is. Problem open. Obliged, lordship.
Please,
Copy. My lord, in this case, my lord, a petition was served, my lord, by speed post lordship, but some pages were, my lord, missing in the petition lordship. Page 83 to 106. My lord, that is the problem to my lord to prepare with the case lordship. So unless these copies are, my lord, served.
Learned Council for the sole respondent submits that although he has received the copy of the criminal revision petition, the same is incomplete. For the petitioner to serve a complete set of the petition within 3 days. Is the matter again on?
13 January.
Is you. Thank. Obliged.
We have, what?
My lord, before my learned friend starts, my lord, I appear for the report. That's why I've said before my learned friend starts, my lord, I appear for the respondent number 2, the informant. My lord, I need further 3 weeks time to file my objection. My lord.
Lord, I have a request. On 16th of July, the status report was sought for by this honorable court from the police. Till date, that status report has not seen the light of day. On every date, the police come and say that we need further time. Now, this respondent number 2, who has been impleaded, he was impleaded on 17th of November 2025. On that date, time was sought to file an affidavit in response. It has been 2 months. Again, no affidavit has been filed. I am only requesting Your Honor to fix a short date wherein both the respondents are directed to file the status report and the response as a last opportunity so that this matter may be argued. It is a very small matter. I have not even been named in the FIR. Therefore, I would request Your Honor to grant a short date with a preemptive direction that the right.
What about the report from the OC Bharalumukh
My
police
lord,
station?
yes, I am trying to get the instruction as per my already, my lord, as per my verbal instruction, case has already been transferred to the CID, my lord, probably. Regarding, I have not, till now, I have not received any written instruction for that. In that case, my lord, from where I will get the status report, first I will need to clarify, my lord. Thereafter, my lord, your lordship may kindly allow some time. In the meantime, my lord, if case has already been transferred to CID, then also.
Lord may also keep in consideration.
Just one.
Otherwise, he is already
Two
protected.
separate
He is
cases. The
already
ID case
protected.
was of general nature of all the land grabbing cases at that time. I am a bona fide purchaser, so I was granted bail. Everything was done in a systematic way. When my son was sought to be implicated in this case, he was granted anticipated bail on day 1, even without two. So at least they should unnecessarily not drag this lady into this case. So your lordship has asked on a number of times to come out with the report. I don't know why they are not submitting the report. And I have my brother coming all the way from outside. So
My lord, regarding unnecessarily dragging of the present petitioner regarding.
no, charge sheet has also not been filed.
Whether is because in this case, my lord, there are.
I will request my friend to submit from the record. He should not guess his
Yes.
submission.
Yes, yes.
Because I have been dealing with this case from day 1. So I know what is in this matter. Lordship may have it in the just after first week of February. Yes. Because they will have time. Today is only 20th.
Third learned counsel for the petitioner, learned counsel for respondent number 2. Praise for further time to file affidavit in opposition. Report of OC Bharalumukh PS has also not been received. Learned additional PP to apprise the court as to when the said report would be furnished. During the course of the day, you get in touch with OC Bharalumukh PS. If the report doesn't come within a week, he's going to come himself.
Lordship may fix it on 18th, my lord, 18th of February.
Let them have it on 18. Only thing is that they should come with a report. Courts directs them to furnish the report, they should furnish it. You can take it on 18. I have no problem on that.
Is the matter again on 18? 18-2.
18-2, my lord.
Interim order passed earlier to continue till the next date of listing.
A copy of this order may kindly be served.
Copy of this order be furnished to learned additional PP.
Now this is not required only. We have all the online copies with the QR code and all. Obliged, Your Lordship.
May it please your lordship. There was a direction for calling of the records from the court of learned ADM Kachar Silchar, which I think has not yet been received.
Third learned counsel for the petitioner and learned additional PP. Affidavit in opposition has been filed on behalf of the respondent. But the case record is called for from the additional district magistrate Kachar Silchar has not been received. Issue reminder. List the matter again on interim order. First earlier shall continue till the next date of listing.
8 minutes. Oblai dosh.
May I please, your lordship? By way of the present petition, your lordship, the petitioner has put to challenge the order taking cognizance, your lordship. Your lordship may kindly come to the order at page 40, your lordship.
40.
40. That's the order against the three of the petitioners, your lordship, who are mother, father, and brother of the main accused, your lordship. Now, your lordship, including section 6 of POCSO Act, your lordship. Now, your lordship may kindly come to the FIR at page 19.
Who are the petitioners?
Petitioners are, your lordship, mother, father, and brother of
Names,
the
names,
accused person.
name.
Named, your lordship. Mother, no. Brother, three brothers, your lordship, and one, so fourth one is father. 1, 2, 3 are brothers, and fourth one is
These persons mentioned in the order.
Yes.
Nauruddin, Ayub Ali,
Yes.
Afzal Ali, and Hanif
Yes,
Ali.
yes, your lordship.
Yes.
These are the persons mentioned in the order. Now, your lordship will kindly come to page 19, that is the FIR, the allegation against the petitioners, your lordship. May I read, your lordship?
Lordship, before starting, lordship,
Hold on.
we have received this TCL lordship. Lordship, TCL is eligible lordship. We cannot go through the even one pages. I could not go lordship.
Problem is this, your lordship, there is no stay order, your lordship. And we are facing, your lordship, and this is.
Let's go to the FIR.
FIR, your lordship. With due respect, I beg to state that the accused number 1 above named have love relations with my niece, namely Miss Mabuni Begum, and by inducing her for marriage, he has maintaining physical relationship with her. She is now 6 months pregnant. In this regard, when we are trying for settlement of the matter with the family of the accused number 1, the accused person avoided the settlement and sent the accused number 1 to Kerala about 3 months ago. While our family members requested the accused person and suggesting them for asking the accused to number 1 to return and settle the matter, they have not given any importance in the matter and scolded us with filthy language and have been threatening us. My niece so-and-so presently read in class 9 and she could not go to school. At present, her age is 15 years. Now, on the face of the FIR, your lordship, how can your lordship section 6 can be attracted against me? Ask your lordship. And not only section 6, other sections also, your lordship. Your lordship, 64(2) punishment for rape, section 81 cohabitation caused by a man deceitfully. Nothing can be attracted against me. And learned court below, your lordship, learned trial court, your lordship, very mechanically, your lordship, issued the order taking cognizance, your lordship, on the same sections, your lordship. And in fact, your lordship, this they have police has submitted
Section 6 and
section
there-
6 as well as section 64(2), that is rape, punishment for rape. Section 81, cohabitation caused by a man deceitfully inducing a belief of lawful marriage. Then 296, we can, that there is an allegation of using obscene words, section 296. And section 351, criminal intimidation, and section 6 is aggravated penetrative sexual assault, your lordship. Now, these section on the face of the FIR cannot come against me, your lordship. They went for settlement. The allegation is that we did not. Now my our son is facing your lordship trial, your lordship, before the juvenile board, your lordship, since he is a minor, your lordship. And so far as we are concerned, they have submitted absconder searches without even arresting us, without even asking us to give statements, your lordship. Now that is why we are apprehensive, your lordship. Ultimately, if we appear, we will be put behind bar, and for no fault of us. And your lordship will kindly see the manner in which search sheet has been submitted, your lordship. What exact role the petitioners in the offense, that has not been disclosed by the search sheet, your lordship. That's what Apex Court has says, that when search sheet is filed, exact role of the accused will have to be mentioned in the search sheet. Now, this is a search sheet, your lordship will find it at page.
All right, hard learned counsel for the petitioner, learned additional PP submits that the 10 copy of the TCR has been received, but not a single page is legible. Where has it come from?
Amingaon.
And the court proceeding court record has also not come.
And,
On the CD part has
and
come.
the record of the court proceedings have also not been sent. Learned CJM Kamrup is directed to ensure proper
It's a lordship special judge Pokso Amingaon.
special judge Pokso Amingaon to ensure that legible and complete set of the 10 copy of the TCR is sent. Having perused the FIR, contents of the FIR as well as the charge sheet. Further proceedings in so and so is are paid till the next date of listing. List again on.
Lordship.
State lordship, otherwise lordship, so far I know lordship, the witnesses lordship, some statements are implicating them lordship. Our fellow lordship could not go their lordship, but for I know lordship, lordship may see the last part. They have lordship, all the episodes lordship implicated them lordship. They have the full responsible of the offense lordship.
Now say how they are involved in section 6 POCSO.
Section 6 may be there, but they are not praying for amendment of the section lordship. Yes, 6 may be there lordship. But some sections.
If section 6 goes, your lordship, POCSO court cannot take cognizance, your lordship.
So they are not playing for lordship modification of
That is
section.
where we are staying. If section 6 is not retracted, how does POCSO court proceed with the case as against the present petitioner?
Deeply obliged.
May kindly be taken up after 2 days. my lord. I'm
After 2
appearing-
days?
Yes, my lord. I'm appearing on behalf of Lanet and
You have not received your CV list.
He did not receive list again on.
That will come in TCL lordship, in item 23 lordship.
TCR not received.
May I please, lordship? The regular bill application, lordship.
The petitioner was arrested on 4 December, Lordship. As on today, Lordship, 46 days in judicial custody, Lordship. And during the custody, Lordship, 3 days, she was in police custody, Lordship, and she was thoroughly interrogated by the police and Lordship may, so far as concerned allegation, Lordship may come to page 15, Lordship. FIR. The petitioner before Lordship, she is a president of a NGO, Lordship, running in Silsor town, Lordship. There are some allegations against her that from her mobile, some defamatory video has been published, Lordship. And also, there is also one allegation that her associate has been received an amount of rupees 20,000 for shifting of a soap in Silsor town, Lordship. These are the only allegations, Lordship. But police has registered the case, Lordship, so many sections, Lordship. There are 12 sections in this case, Lordship, and police has registered the case under section 111.3, 111.4, 111.5, 111 subsection 6, 117, 296, 308 subsection 5, 318 subsection 4, 351 subsection 2, 353, 356 subsection 361 subsection 2. So far as concerned, Lordship, 111, Lordship. In this case, 111 does not attract, Lordship. The scope and ambit of the section 111 organized crime does not come into effect in this case, Lordship. Only, Lordship, so far as allegation is concerned, Lordship, 296, the option acts and songs, 318, cheating and dishonest, and 356, subsection 2, criminal intimidation, and 356, statement conducing to the public mischief, and 356, subsection 2, defamation, and 61, criminal conspiracy come only attack in this section. And if this section attack, Lordship, there is maximum period of detention, Lordship, 60 days. And my humble submission is that, Lordship, already 46 days in judicial custody, Lordship, 3 days in police custody. So she was thoroughly interrogated as she is being a lady, Lordship, and good reputation in the society. But anyhow, she was arrested, already learned a lesson, Lordship. With any conditions, she may be released to go on bail, Lordship.
My lord, I have received the case diary. My lord, I will point out there are sufficient in the name of running an NGO, my lord. How he, my lord, indeed thereafter, my lord, indeed she along with her associates, my lord, in the name of settlement between the settlement of dispute between the parties. Thereafter, my lord, she in fact himself created disputes. Thereafter, demanding money, my lord, from those, my lord, victimized person. Your lordship may kindly peruse too. And there are lots of numbers of, my lord, supplementary affairs against the present accused persons. Those are also annexed. Your lordship may kindly peruse two statement of the two victimized person. How, my lord, in the name of settling the disputes, my lord, and he, in fact, my lord, in these two statements, my lord, it reflects that one of the victimized person. For supplementary affairs also.
May I submit, Lordship?
Very distinguished.
Lordship, this is the first time before Lordship, last 15 years running this NGO, Lordship, this is the first.
Last time she got caught.
First, Lordship. And so much FI is concerned, Lordship, only the video viral and receive an amount of rupees 20,000, Lordship. So maximum punishment is 7 years. So stated period 60 days, as on today 46 days. And 3 days in police custody, Lordship. And thoroughly interrogated by the police, Lordship, investigation must have progressed, Lordship. And learned friend raised that other FIR against her, but till 46 days, they have not shown arrest by the police, Lordship, me. So that cannot be counted at this moment, Lordship. So my humble submission at Lordship, the maximum punishment is 7 years, 46 days in judicial custody, 3 days in police custody, fully indicated by the police. No purpose will be served, Lordship. By custodial detention is not required, Lordship. And moreover, Lordship, I come to page 26, Lordship. My petition, Lordship, page 26, Lordship. Last part, Lordship. The ground of arrest communicated to the arrested accused person by issuing notice under section 47 BNSS. Arrest memo and inspection memo have been duly served to the arrested person. Inform the guardian family members by issuing notice under section 48 BNSS, medically examined by him by the gov doctor. But section 36 has not been complied, Lordship. So it is a illegal arrest, Lordship. And the coordinate bench already passed several orders, Lordship. I will place before the Lordship. The 36 one is violate to is a illegal arrest, Lordship.
How is it not complied with?
Forwarding report not reflect anything that they have complied section 36. Its forwarding report clearly shows that they have not complied. And Lanak coordinate bench already discussed about the section 36, and when 36 is violated, then the arrest is illegal, Lordship. And in NDPS cases, Lordship, coordinate bench released the accused person on bail, Lordship. So it is a case of 7 years punishment, Lordship.
Not a 7 years punishment, my lord. Not a organized crime is also there. Lots of
Organized crime does not come into effect, Lordship.
filing 30 days, 90 days, my lord.
Lordship is if you look the BNSS, Lordship, for a moment, Lordship, 111.
Yes, read.
The organized crime definition, Lordship, may kindly see any continuing unlawful activity, including the kidnapping, robbery, vehicle theft, extortion, land grabbing, contract, killing, economic offense, cybercrime, trafficking of person, drug, weapon, or illicit goods of service, human trafficking for possession or ransom by any person or a group of person. That means organized crime. But so far as the allegation is concerned, organized crime does not come into effect, Lordship. If we can show that, I have nothing to say, Lordship.
I will check for the
Allegation only video viral and receive amount of rupees 20,000, Lordship. By her associate, Lordship. Not directly also me, Lordship.
It is only as per the FIR, but CD reveals something else.
Yes,
A city reveals something else and also said that some FIR is also against her, but till today not shown as by the police.
The FIR is not the encyclopedia of everything. Those FIRs are registered as, my lord, supplementary FIRs during investigation of the present case. All those things, my lord, in which the present petitioner is involved, my lord, everything comes out. So, my lord, this is not that
It is not a heinous crime like my learned friend described before this court, Lordship. In NDPS cases released by this court, Lordship, but it is a.
They will see the CD whether 36 has been
Yes,
complied
Lordship.
with.
Yes.
Anything to say on compliance
Yes.
with 36?
My lord, I will point out, your lordship, I will have to go through the case diary, money.
CD to do.
After some.
Deeply obliged, Lordship.
से केस डायरी was for
He did not receive.
उसमें क्यों after a week मैंने
He did not receive list again, no?
The Bistari.
9th,
No, 28th of June.
30.
30. Of last month.
Back, please, Your Lordship. Lordship, in this case, the
My lord, here
petitioner-
charge sheet submitted, my lord.
petitioner is in interim bail, my lord. That this bail may be absolute, my lord. Government servant, my lord. Working in a railway department. Interim granted on 26/2005, my lord.
Charge sheet is submitted.
My lord, charge sheet submitted, my lord. I charge sheet number 187 of 25, dated 6/8/24.
Second copy of this here. Along with the CD.
February, my lord, 26th of February. 25. 25, my lord.
Apply to. Interim continue. Interim, other interim will continue.
Interim order passed earlier to continue.
Your Lordship, in this case, CD was called for, my lord. I'm on interim, my lord. I have appeared before the IO, my lord, and recorded.
Here CD not received, my lord.
Did not receive list again on
26 February.
Till then, my lord, interim may continue.
this interim.
Online, my lord.
Item 28, 29 are same, my lord. The same FIR.
But I'm for the, I mean,
Received.
CD received, my lord.
as per the instruction is concerned, Your Lordship, the accused petitioners went to the police station after getting the interim protection before this. Their statement has been recorded. So my respectful submission before this honorable court, Lordship, that kindly the absolute protection in connection with this.
Here, after interim, they have appeared, my lord. Their statement also recorded, my lord. Regarding the injury, my lord, Lordship may kindly please. Medical. Victim also implicated him, I guess.
So simple injuries.
Fine.
Dated 27. 4. CDS call for has been received along with the injury report, which reflects only simple injuries. Para having regard the arrest bail is allowed. So order of interim free arrest bail dated 27/8/2025 is hereby made absolute.
Item number that is 29. He is appearing. in
I'm
item
for
29.
item number.
But item
29.
20 is also same FIR, same, they have also,
28, nobody is coming.
nobody is.
28 say none appears, okay, and then rest is same.
Much obliged.
CD will return, madam. After that, CD already.
Returned.
CD will return, madam.
We have made of absolute.
No, no, madam, that is item 28, madam, none appears, madam. Same CD, madam.
We are disposing of.
Fine. 28 also, well.
Okay, order. Totally none appears.
None appears, madam, here also.
None appears list again on.
Last part of February, madam, 27th, madam.
Copy of TCR received लिखी by to.
May be please, so in this matter, CD was called for.
He did not receive, my lord.
It is the 5 times short dead may be given. So is Dergaon police station, my lord.
There you go.
There is not any inquiry, my lord.
This is the fourth date.
My lord.
Four times earlier.
My lord.
CD not received.
My lord. Short that may be, my lord, 30, my lord, 30. 30, my lord.
Third learned counsel for the petition and additional PP. Is the areas called for has not been received. Order sheet reveals that this is the 5th occasion on which the IO has failed to produce the CD. IO is granted one last chance to
Right.
produce the CD on the next date fixed. Failing which the reaction will be initiated against the IO.
30, my lord. 30.
Indicate a copy of this order to the OC, Dergaon PS.
My lord.
Pass on.
In respect of item number 19, my lord, I would like to point out just now I have received a report from the OC Bholamukh Police Station, my lord, regarding transfer of the case to the, my lord, CID Assam Police, my lord. So, my lord, status report may kindly be called for from the officer in charge of the CID Police Station, my lord.
Number 19 to Belake Ulay Devotion or whatever. That order to Punel Ulay. Learned additional PP has received instructions. Written instructions that the Bholamukh PS case number 357 of 23 has been transferred to CID Assam. Call for the status report from the CID, some police station.
Item 34. Search it submitted, my lord. Search it submitted.
That's it. But for the informant, my lord.
That's
Last
it,
occasion
submitted.
submitted the medical report, my lord.
Yes, petitioner.
Lordship, the English Council on Lake in another court. Pass over the matter for time.
Maybe he will agree to appear.
That is.
Yes, my lord. He's on interim from the summer court. Medical report, my lord.
Already it is submitted that CS has been submitted by.
Search
CS
sheet number 133 of 25 dated 30/11/25.
A scanned copy of the PCR along with CD. Is again.
শেষ কৰিব লাগিব সেইটো ফেব্ৰুৱাৰী লাষ্ট 27th. My lord, here we have not received case there, my lord. They are in interim.
We did not receive. List again on so interim order passed that continue. Till next date
26,
of
ma'am.
listing.
26 too.
Obliged.
My lord, here also CD not received, my lord.
Interim is there.
Perhaps
No.
interim na, no? Bongaigaon. 3182 is there. My lord. 12 February. 12 February.
Right, Lordship. Here, interim is there, Lordship.
CD not received, my lord. Interim is
Interim to continue.
27th month. 27 to.
Sorry.
27 to February.
No, Lordship. For execution, Lordship, FIR page 15, Lordship. I was called for, Lordship. We have also filed a case, Lordship. Both that I was called for. Petition.
I have received both the case they received.
Dispute regarding product of land, Lordship. Informants are also attack as, Lordship. FIR against us page 15, Lordship. 1.5 the type copy, Lordship.
This is a murder case.
Yes, Lordship. We are also injured, Lordship. We are also in ICU, Lordship. We have also filed on same date, Lordship. FIR against us, Lordship, page number 15, Lordship. Next.
Yes, PP.
Yes, my lord. I have received the case diary of both the case, my lord. And here from the case diary, my lord, incident occurred on, my lord, 10/10/25 at about 11 AM, my lord. Here there are, my lord, from the postmortem report, I would like to point out, my lord, death was due to coma as a result of injuries sustained over the head as described. All injuries were antemortem and caused by sharp cutting, heavy weapon and homicidal in nature. And regarding the involvement of the present accused persons, my lord, here there are three accused persons, one Azmot Ali and Bilal Ali and Saddam Ali. My lord, here, my lord, the one, my lord,
Azmot Ali Lordship, Bilal Ali and
Azmot Ali, Bilal Ali and Saddam Ali, my lord. Here, my lord, one Rosmil Ali, who was died on spot, my lord. These accused persons in a group, my lord, along with my lord, Da, Degar, Rod, my lord, they attack all these accused persons. They are while, my lord, in their agricultural land, my lord. At that point, regarding the present accused, my lord, Hasmot Ali, there are, my lord, sufficient witnesses, my lord. In fact, the Hasmot Ali is the person who cut the, my lord, left arm of the, my lord, deceased, and thereafter he died on the spot. And thereafter, my lord, here there are statement of the injured, my lord, witnesses is also there. But regarding injury, my lord, those injury reports are some other persons, my lord, as per allegation, also injured. Regarding those injury reports are not available. But there are eyewitnesses of all those accused persons are available. But all implicated, mainly, my lord, Hasmot Ali, he is the main accused. He is the person, my lord, who cut the left arm of the deceased. And thereafter, all those accused persons, other two accused persons were also present on the spot. They also assaulted regarding that aspect, my lord, all is statement of the 183 statement is also available of the injured person.
For the attack of the informant side Lordship, we are also injured Lordship. They are also in
Yes, what does the other CD say?
CD, my lord, there is nothing. That is, my lord, thereafter, after the incident, they lost the FIR, my lord, on my lord 13, not on the same date, on 13/10, my lord. Incident occurred on 10/10/25. The present FIR is of 11, and they lost thereafter, my lord, only to save their skin, my lord. On 13, they lost the FIR, my lord. Regarding that CD is also, my lord, available. There is nothing in that CD, my lord.
Learned counsel for the petitioner. This is an application. The CD has been received along with the CD of Azopius case number 433 of 2025, which is in connection with the cross FIR submitted by the petitioner side against the informant side of the sent application. The patients as contained in the FIR.
Yes, 16 delivery motion Lordship.
Three. As per the postmortem report, the deceased died as a result of antemortem died due to coma as a result of injuries sustained over the head, and all injuries were antemortem and caused by sharp cutting, heavy weapons, and are homicidal in nature. The contents of the CD, including the statements of witnesses, have clearly implicated the present petitioner. As far as the CD of the cross FIR lost by the petitioner side, There appears to be no material against the accused persons therein. That is the informant side of the present case. That I'm having regard to the above as well as the grave nature of the offense. Therefore, bail is rejected like the CDs. Here is bail.
May I please alone?
My lord, in the yesterday, my lord, that case was listed, my lord. I have received the, my lord, bail objection along with the, my lord, report that he has not appeared before the IO after getting the interim. Earlier, he has appeared twice, my lord, but after getting interim, he has not, both of them not appeared, my lord. Two petitioners are there, my lord.
Earlier notice was issued, we appear, our statement has been recorded, my lord.
Our not, my lord, only one person appeared. Petition number one, Abdul Khalik appeared, other not appeared. In the earlier, my lord, as per notice, my lord.
Was issued only number one, my lord. But my lord, sometime may be given, they will, I will take instruction. As per my instruction, my lord, they appear on 18/7. But whether their statement has been recorded by the IO, that does not.
Abdul Khalik appeared on 10/7 and 18/7, my lord, as per notice, my lord. But after interim, my lord. After interim, both of them were granted interim, my lord, but both of them not appeared, my lord. Here's the petitioner number 2 is the brother, brother of the petitioner number 1, my lord.
It is learned, submitted by learned additional PP that as per instructions received, the petitioners have not appeared before the IO pursuant to interim protection granted by the court. Although the petitioner number who had appeared?
Abdul
Number
Khalik.
one.
No,
Number one.
after interim not appeared,
No.
but before Abdul Khalik, petitioner number 1.
So the petitioner number 1 had earlier appeared before the IO pursuant to notice under section 35 DNSS. Full stop. Para learned counsel for the petitioner seeks extension of time for appearance before the IO. Accordingly, it is directed that the petitioner shall appear before the IO within a period of 7 days from
My lord.
today. Also, please the matter again on.
For up to date, my lord, CD, that is my lord, 16th, my lord,
Also call for the up-to-date CD.
16th February.
There may be continued. There may be continued.
Interim order passed earlier to continue. Yes.
May please your lordship. Lordship, criminal appeal prepared by the appellant, conviction under section 279.
Appeal or revision?
My lord. Division, my lord. Yes, criminal division of conviction under section 279 and 304A, my lord. Lord, 279 1 month imprisonment and 304A 6 month imprisonment, my lord. If there is a notification of the government of Assam 21/10/2022, punishment below 3 years, my lord, it may be converted to fine amount, my lord. It may be converted to fine amount, my lord.
Who will convert?
My lord, court will convert, my lord, notification.
To the PT offense notification, learned friend is submitting on the basis conviction of 1 month and 6 months in this case, lordship. Lesson negligent driving and subsequent was already admitted, lordship.
Is it fixed for orders then?
Lordship, the records were called for. Maybe there is a mistake in the order, so
Order.
the records not yet received, Lordship.
There is mentioned in share case number, my lord. Share case number 13028, but it may be GR case number, my lord.
Instead of GR case, in the order it is reflected as CR
CR
case. Learned friend can argue that point, Lordship. The revision petition already admitted if you wants to convert it after receipt of
LCR as called for has not been received. Hence, due to quoting of wrong case number, hence call for the scanned copy of the TCR of
GR case.
GR case number
13028.
13028 stroke 2013.
From the
Where is
learned
this from? CGM Kamrup Metro?
Yes.
From the
Lordship.
CGM Kamrup, Amingaon. List again on.
From Amingaon, Lordship can give a short date and thereafter it post up, Lordship.
Bless Lord.
I'm appearing as an amicus.
I plead your lordship. What happened, my lord, in this case, my lord, I could not trace out the file. So I may be given a short accommodation. I will apply for the copy of the appeal memo from the registry, my lord. It will come last part of the February, my lord.
Mr. S.C. Biswas, Learned Counsel for the petitioner, submits that this being an old case, the file could not be traced out. 6. Further time. Kindly list the matter again on.
Right, my lord.
Give.
Right. I don't have time, a little more. Then I will apply for the copy.
Yeah, just I got an information that respondent has already expired.
Respondent counsel does not have the information.
No, my lord.
And you are appearing for respondent.
Yes, 2/1/2025 he expired.
Then, my lord, his legal heir, my lord, is responsible.
Then you make them party.
Legal heir, my lord, because demand notice also it indicates that his son also liable, my lord. Page 40, my lord. If 40, my
When
lord.
did he expire?
2/1/2025.
2/1/25. So limitation is also gone.
Today I come to know.
And take a step.
You may come to know, but your client, the legal
Let
names of
know.
your client
Let
knows.
know.
Learned friend just informed to the report today itself.
Let also know.
So, respondent counsel to inform today, my lord. So I come to know from his information.
Right, it is
And page, my lord, 40.
submitted by Mr. J. Ahmed, Learned Counsel for the respondent number 1, that the said respondent has expired. And a copy of the death certificate has been furnished, wherefrom it appears that the respondent number 1, namely P.R. Abdul Khalik.
That certificate also received today, Your Lordship.
Had expired on 02/01/2025. That counsel for the petitioner submits that he may be granted time to file application for implement along with the application for condonation of delay in as much as he
Lordship, it may be note, my lord, the
has come to know.
that certificate also I received today.
As much as he has come to know about the fact of the death of the number 1 only today. Is the matter again on?
Lordship, in the meantime, my lord, I will file appropriate application.
What we have said.
Right.
None appears for the petitioner. Place the matter again on. একমাস পিছত ফেব্ৰুৱাৰী লাষ্টৰ ফালে দিটো।
May appeal Lordships.
But your client is nameless.
Lord. Lordship.
Client is named X.
Yes.
X.
Yes. That is the rule.
Practically, family
Yes,
court order.
Family court order.
Challenge the family court order on maintenance, Lordship.
Milord, in this case, Milord, earlier, Milord, learned court below allowed 7,000 Milord. And a respondent filed a miscase for increasing of the maintenance, Milord. On 27/8/2025, Milord, learned court below allowed 24,000 per month, Milord, as a maintenance, Milord. Without considering the fact that, Milord, a petitioner is drawing salary, a net salary 54,994 rupees, Milord. In this case, Milord, as per Supreme Court, Milord, the 25% of the net salary would be just and proper to as a maintenance to the respondent, Milord. My prayer, Milord, out of 55,000 salary, Milord, 25% may be adjusted as a maintenance.
Where is the order?
Yes, Milord. Final order is page 40. Relevant part is page 46, bottom, Milord, order, Milord.
Very above, 46. Order to.
Yes, which para
Millet,
of the judgment?
para 15 minute, 1 5.
কোনটো judgment দিছে?
কল্যাণ দে চৌধুরী। Salary slip is page 48 million. Last August million is 48. And net salary 54,994 million. This is August million. Last August 22.
Net amount 54,994.
Yes, million. After deduction million. The petitioner is ready to pay the maintenance to the second wife. A petitioner is ready to pay the maintenance million.
The the amount that is given now 24 is comes to what percentage?
24% is the high million. 25% means million out of 54, 13,736 million. Out of 54,994 million.
Not possible.
And that is the calculation.
The case you have cited, that was only for the wife.
And no, Miller, that is the only
Here
son
the-
also Miller. Son also Miller.
No, I don't think there is some.
In the interest of justice, we think it proper to reduce the amount or the maintenance 23 to 20.
It is the
20
husband's
per
son.
the maintenance to the respondent wife and son. Last sentence of the 15th paragraph.
Then proper to be awarded as 20 would know, following Kulbhushan Kumar and Raj Kumar. In this case, it was held that 25% of the husband's net salary
Yes,
would be just and proper to be awarded as maintenance to the respondent wife.
yes.
So this 25%, as far as 25% is concerned, it is for the wife only.
Yes, my lord,
But if
bottom,
there
my
is-
lord,
there are
bottom, my lord,
children-
the last sentence, my lord, also kindly consider. However,
That is,
since the appellant has-
that is because the appellant got married for a second
my
time
lord,
as
the
a child of
petitioner-
his own.
Yes, my lord, petitioner also got married, my lord, got children, my lord. Same fact and circumstances. Petitioner also got second marriage and got childed.
Yes, Mr. Poddar.
Lordship, there two petitions are there. One, they have come up for reduction, and I have filed a revision, Lordship, for enhancement, along with modification of the date of the award. In this case, Lordship, as pointed out by my learned friend, Lordship, at page 47, last paragraph, Lordship. This order shall be effect from the date of first week of September 2025, Lordship.
Yes.
As per the Rajneesh versus Neha, Lordship, it is now established law. Every award for a maintenance must go relate back to the date of petition, Lordship. Here we have filed that revision, Lordship. First, changing the date of order to the date of petition. It will be 2022, Lordship. Our petition is of 2022, Lordship. Now coming on the quantum part, Lordship. But they have stated in their affidavit, as far as this versus Neha, in every maintenance case, Lordship, they have to give an affidavit of assets and liabilities. If your Lordship look at, take my petition, Lordship, the petition under 498, criminal revision, Lordship. Section not in dispute, marriage. I am living with one daughter, now 11 and 12 years old. For the first time, my friend has submitted regarding second marriage. Nowhere in the written objection against my petition for enhancement, nowhere stated that he is second time. And I request Lordship to note it down in the order, Lordship, that they have got second marriage because he is a government employee without divorcing me. Cannot. Though religious rights, nowadays it has also been banned. He cannot have the second marriage without the permission of the authority. When I filed the RTI to their authorities, they have refused no marriage, nothing else. Even in the written statement, they have not mentioned that part. So I will humbly request whatever my brother has submitted, so that we can proceed with that part also. Now coming on the merit part, Lordship. Admittedly, yes, whatever the salary he has stated. In the affidavit, Lordship, at page 26 onward, Lordship. with my petition, Lordship. Annexure 3. Their affidavit is totally casual.
Yes, affidavit is that?
26, Lordship. The first page of the affidavit and enclosure 1 as per the Rajneesh versus Neha, Lordship. B. Legal proceedings. C. Details of dependent family members. Details of dependent parents. Respondent is the son of a retired additional SP, Lordship. That has been admitted in his cross-examination during the proceedings, Lordship. His parents cannot be dependent on him. He has mentioned about daughter and wife, which I mean he relates to us, not of his second marriage, not of his second child. Age, sex of the dependents, nothing has been mentioned, Lordship. Whom, according to us, so far his disclosures in the office, no mention, he is alone.
That is not in dispute. That has been reflected in the impugned order itself that he has no other dependents.
Yes, Lordship. Under that factor and circumstance, how to determine the amount? 56,000 is there. According to us, we have given our affidavit. He has fisheries. He has rented properties. He is a rich man. We have mentioned in our property, Lordship. Now, coming to quantum, how to be fixed, Lordship? I would like to rely upon one judgment of Honorable Delhi High Court, Lordship. Harminder Kaur, I am furnishing the copy, Lordship.
Yes.
In the Harbinder Kaur judgment, para 3, last paragraph, Lordship. In the aforesaid proceed, income has to be equally apportioned for the maintenance of wife and child. If we divide income of the respondent, that is rupees 12,000, in 5 units, that is the formula Honorable Delhi High Court followed, Lordship. 2 units for adults and 1 unit for young child, then the wife is supposed to get maintenance of rupees 4,800 out of 12,000, that has been calculated, Lordship, per month, and the child is also supposed to get 2,400 per month. All petitioner must get 7,200 per month as maintenance, that is out of 12,000. In our case, Lordship, if we take this 54,000, Lordship, divided by 5 units, even roughly calculating 50,000 by taking the tax liability, etc., PPF liability, 5 units, 10,000 each. Wife is entitled for 2 units, 20,000. Child is 1 unit, 10,000, 30,000. What we have paid for in the trial court, Lordship, under 120. Secondly, so far the date of order is concerned, a date of maintenance petition is concerned, Lordship, I have relied upon one another judgment, Seema Agarwal, that is also Honorable of Calcutta High Court, Lordship. I have given the copy, Lordship. Para 5, Lordship. Only the issue determined by this court that whether the order passed under section 127 of the Code of Criminal Procedure can be ordered to be effective from the date of passing of the order or from the date of filing the application under 127 of the Code of Criminal Procedure. At para 9 and 10, Lordship, following the observations of Rajneesh versus Neha, it appears to me that Honorable Supreme Court has framed the different guidelines and said judgment, including the guidelines that all the cases of compensation, the order should be take effect from the date of filing of the application, not from the date of order. Considering all aspects, I find merit to entertain the instant criminal revision application. The order passed by the learned magistrate is hereby modified to the effect that the impugned order dated 24/11/27 shall be take effect from the date of filing of the application under the 127 Code of Criminal Procedure. In our case, Lordship, the impugned order, we have requested for changing the date. That is from the date of our petition, Lordship. That is 30th-9/2022, Lordship. So our prayer is for enhancement from 24,000 to 30,000, Lordship. As Lordship rightly observed, this 25% part is only for the wife. Even if that is taken, Lordship, then it should be 18,000. Sorry, 16,000, Lordship. 27, 13,000. Court has given us 12,000, Lordship. So for Rajneesh versus Neha judgment, Lordship will require, Lordship. That is the
That is
citation.
already quoted here, I think.
Yes, Lordship. And so far the standard of life, accept being vast experienced court, Lordship, in the Samima Faruqi case, Lordship, it has been. So far deductions are concerned, Chaturbhuj case is there, Lordship, that only the statutory deductions is permitted, non-voluntary. This LIC premium, etc., that cannot be deducted from the income. My humble submission, Lordship, it should be enhanced, and that to be from the date of petition, Lordship.
CAV.
Order. Order.
Twenty-four, my lord, I have flag mark index CD, my lord.
Lordship,
Yeah.
my senior counsel is in another courtroom.
Only just to point out that aspect regarding.
We have already heard.
Yes, ma'am. Only regarding, my lord, compliance of section 36(3), I have flag mark, my lord. Arrest memo is there, signature of the arresting, my lord, relative or friend is also Raju Pandey, my lord. All seven. There also none appeared, no.
None appears. List after weeks. কি করি এটা? করা নাই কোনো বাবু? We have already passed orders in 47.
Can it be heard at 2 o'clock? Senior counsel was he is in other court.
Pay counsel is also not there. We have fixed the date anyway.